My name's Tammy Slaughter, and I'm with the Marion County Children's Alliance, and I am here today to talk to you about the law. This presentation is brought to you in partnership with the Community Council Against Substance Abuse, Lutheran Services Foundation, and the Community Coalition Alliance. And thanks for having me here today. Let's get going. So what we're going to talk about today is the law and how much you think you may or may not know the law. I'm going to ask you 8 questions and see how much you know about the law. And then we're going to ask you the same 8 questions at the end of this presentation and to see if you have learned anything. The first question: what could happen if you get caught with alcohol on school property? And here's your choices. Question number 2. You do not have to be the person committing a crime to be charged with that crime. Is that true or false? Question number 3. When you actually touch or hit another person against their will, the crime is called what? Question number 4. Can any adults at your house be charged if you have a party and alcohol or drugs are being used by people under the age of 18? Question number 5. A teenager can be charged with a crime if they make threats to hurt others using social media, text, or email. True or false? Question number 6. Having more than 3 grams of synthetic narcotics like spice, K2, THC oils is a felony. True or false? Question number 7. Sending or sharing nudes of yourself or anyone under 18 is against the law. True or false? And question number 8. What can happen if you're charged with grand theft, which is stealing property valued at more than $750? The purpose of this presentation is to provide you with a better understanding of the law to hopefully help you from breaking the law unknowingly. It's really important to remember that ignorance of the law is no excuse for breaking it. And what that means in simple terms is just because you didn't know you broke the law doesn't mean that you are free from the consequences of breaking that law. There are 2 basic types of crimes we're going to talk about today: felonies and misdemeanors. Which one is worse? Misdemeanors are still serious. You can, in fact, go to jail for breaking the law and being charged with a misdemeanor, but they also include penalties, fines, and court costs, and up to 1 year in a county facility, which would be a jail. The biggest difference between misdemeanors and felonies is how much time you could possibly go away for. Anything under a year is called a jail. Anything over a year is called a prison. So some examples of misdemeanors include petty theft, simple assault or battery, which we will go over in a minute. So felonies are definitely more serious than a misdemeanor. You can serve up to life in prison for a felony. Some examples of felonies include murder, grand theft, sale, delivery of controlled substances. What's a controlled substance? Anything that is considered to be a drug. Do you think that jewel carts are considered a drug? If you said no, you would be wrong. Absolutely. Nicotine is a highly addictive chemical substance. It's also highly toxic and can send you to the hospital if you ingest too much straight liquid nicotine. In the state of Florida, if you're charged with a violent felony, which means you hurt another person, there are circumstances that would allow for you to be charged as an adult as young as 14 years old. If you are charged with a non-violent felony, then you can be as young as 16 years old and be charged as an adult. So what does it mean to be charged as an adult? It simply means that you could face adult-sized consequences, which does include prison. So if you're only 14 years old and you're charged with a violent felony, do you think that you can be charged as an adult in that instance? If you said yes, you'd be right. In the state of Florida, juveniles as young as 14 years old can be charged as an adult in certain situations. 16-year-olds in the state of Florida can be charged with felonies that are nonviolent. What does it mean to be charged as an adult? It means that you could be facing adult-sized consequences. So now we're going to talk about principal and accessory theory. One of the questions that I asked you was, do you have to be the person committing a crime in order to be charged with that crime? The answer to that question is no, unfortunately. Think of it in terms of if you happen to be in somebody's car and that car is pulled over and law enforcement finds contraband in the glove box. Do you think that you could be charged with the contraband that's in the glove box? You absolutely could be. It's simply a matter of wrong place, wrong time. You do not have to have knowledge of those drugs in the glove box. You do not have to have knowledge of any kind of crime. You just have to simply be there when the crime is found out. Some additional examples of principal and accessory theory would be a getaway driver or look out for a crime, or simply if you provided knowledge that led to the commission of a crime. If it got back to law enforcement that you were the person who let that other person know, then you could also be charged with that crime as well. Now we're going to talk a little bit about crimes against people. I mentioned earlier the occurrence of assault and battery. A lot of people think that that's one crime, when in reality, in the state of Florida, it is considered two crimes. So assault is defined as the intentional, unlawful threat by word or act to do violence to a person. But it has to also be coupled with an apparent ability to carry out the threat. You create a well-founded fear in the person that you're threatening, and such violence is imminent, which means it's going to happen soon. So you combine all of those things together, and then that could be a situation where you might be looking at an assault charge. So battery would be actually and intentionally touching or striking another person against their will to intentionally cause bodily harm to that person. So the difference between assault and battery, one is a threat, one is the physical act of touching another person against their will and harming them. So if you do either of those things in conjunction with a weapon, you would then be committing aggravated assault or aggravated battery. Something as innocent as a calculator would be considered a weapon if you use that calculator in a manner that harms another person. Another form of aggravated battery would be considered the use of a deadly weapon, such as a gun or a knife. So communicating threats of death or bodily injury to a person or their family is considered cyberbullying, and it is a second-degree felony. Written threats to kill or injure another person is considered a second-degree felony, punishable by up to 15 years in prison, 15 years of probation, and $10,000 in fines. So that would be a total of 30 years of your life and $10,000 in fines for sending a message through text, Snap, IM, whatever your platform of choice is, 30 years of your life and $10,000 for sending a message that threatens somebody. So think about that. What are the different platforms that law enforcement consider social media? Take your pick. There's endless numbers of them, and my list is not comprehensive, but it does include Snapchat, TikTok, Twitter, Kik, Instagram. It does also include text messages, but here's a fun fact that you might not know. It also includes Microsoft Teams and Google Classroom. If you're caught sending messages through either one of those school platforms, it's also considered social media. Any platform that allows you to electronically or digitally communicate with anybody else would be considered social media and would be relevant in cyberbullying cases. So what this boils down to is stop being nasty to one another. Be nice, and if you don't have anything nice to say, don't say anything at all. I know it sounds old and cheesy, but really it is the best thing to do in this situation. Unfortunately, once you send something digitally, electronically, it is no longer yours to control. You no longer have a say on what happens with that information. Whether it's an inappropriate photo or an inappropriate comment threatening to harm somebody, or an inappropriate comment to your boyfriend or girlfriend, it is no longer yours. You can no longer keep it a secret from the world. And that's where a lot of young people get tangled up in breaking the law unknowingly, or something worse, like your reputation is damaged, or even further. So now we're going to talk about something that might be a little bit uncomfortable, but it's important that we talk about it. We're going to talk about sexting, sending nudes. It happens. We as adults realize that it happens, and we understand that it is something that a lot of different people engage in, but let's talk about why it is especially harmful for young people. So in the state of Florida, if you're under the age of 18 and you send a nude photo to another person under the age of 18, you've actually committed a crime. Because both of you are under the age of 18, the law considers nudity to be pornographic in nature, therefore shouldn't be in the hands of young people. If the photograph happens to also be of somebody under the age of 18, now you've committed a different crime and you've engaged in child pornography. It's a really, really hard subject to talk about, and it might seem a little bit extreme, especially if there was permission given. But because you're under the age of 18, you're actually not allowed to consent to that type of stuff, so the law will take that matter into their own hands and say that laws have been broken. There was an incidence of violence against a minor way back in 1986, committed by another minor. But it wasn't until 30 years later that the police figured out that this person was under the age of 18 when they committed this violence. And back in 1986, people under the age of 18 were not permitted to be listed on a sex offender registry. But because of that act of violence that happened, young people under the age of 18 can end up on a sex offender registry if they are found guilty of engaging in child pornography. So what are the consequences for sending nudes, other than the extreme consequences we just talked about? Your first offense is going to be kind of minor, a little bit of a slap on the wrist. You might end up in front of a judge. We have a sexting court here in Marion County. It's led by Judge McCune, really nice guy. You probably don't want to be introduced to him in that situation. Really nice guy though. You could end up with several hours of community service and up to $60 in fines. So, I mean, honestly, it doesn't sound like that big of a deal, but now you've got a record of doing this. So your second offense is considered a misdemeanor, and that is an arrestable offense. You can do up to a year in jail for a misdemeanor. Your third offense would be considered a felony, which is much more serious and could mean more money in fines and more time incarcerated. So let's think about this for a moment. Your first offense, your second offense, and your third offense, would that be that you get caught one time and you have multiple images on your phone? Or would that be the first time you're caught, the second time you're caught, or the third time you're caught? The answer to that question is it could go either way. It really just depends on your personal situation, the situation that you are caught up in, and the judge that you happen to be standing in front of, which could be Judge McCune, could be another one.